and I'm the Dean of the Law School at Regent University in Virginia Beach, Virginia. And it's actually my 17th year of teaching there, and I guess my 11th year as Dean of the school. And I hope you've had a chance to meet some of our students while you've been here. I can tell you that although I like lots of parts of my job, the very best part of my job is hanging out with young men and women who have a sense of purpose and calling in their lives and who want to serve God in this profession. So that's my plug for our students, and I encourage you to get to know them. I'm also a dad of 4. And I remember when 17 years ago, I told the family, hey, we're going to move from Wisconsin, where I was practicing law, to Virginia to teach. And my oldest daughter, who was in preschool at the time, she had only one question for me about this whole idea that I was going to be teaching at all. And her question was, so Dad, when's story time? Because that was sort of the key to her educational program was story time at preschool. And I have to say, I've thought about that a lot over the years because I'm a huge believer that stories are actually good ways of teaching. And so what I'd like to do is start with 2 stories today that will help you understand the topic that we're going to cover today, which is higher law and common law. Okay? So here's story number 1. This is a picture, of course, of someone very familiar to all of us, Justice Clarence Thomas. And the story I want to tell you has to do with his nomination to the Supreme Court. And many of you will remember some very difficult hearings before the Senate Judiciary Committee over Justice Thomas. Do you remember what was the big controversy? I mean, this was a few years ago now, but the big controversy over Justice Thomas.
Anita Hill and a pubic hair.
Ew.
Can of Coke.
Yeah, okay, I don't want to go that far into detail now. But yes, it was over Anita Hill and allegations of sexual harassment, that Justice Thomas had sexually harassed her. And of course, it was a very close hearing, a very close vote in the Senate Judiciary Committee. And once those allegations were made, that dominated the discussion in the confirmation hearing for Justice Thomas. Some of you who followed the hearings fairly closely may remember that that was not the only issue that was controversial regarding Justice Thomas, or now Justice Thomas. There was also controversy over a speech that Justice Thomas had made, and this came up before the whole Anita Hill matter, but a speech that Justice Thomas had made in which he used a quote from John Quincy Adams that became problematic. And here was the quote. I want to read this to you. He said, "Our political way of life is by the laws of nature and nature's God, and of course presupposes the existence of God, the moral ruler of the universe, a rule of right and wrong, of just and unjust, binding upon man, preceding all institutions of human society and of government." So that there is some law, this law of nature, this law that comes from God, transcends human law, governs all things. There's right and wrong, just and unjust. And I don't know if you remember, but one of the responses to Justice Thomas using this quote was, well, that's dangerous. That's a dangerous view. It's out of the mainstream. One of the people who is most troubled by this quote was now Vice President Joe Biden, who was very active in the Senate Judiciary Committee at the time. And he argued that Justice Thomas, or now Justice Thomas, was not fit for office if he held to this view. Okay. All right, good. I've got an interactive crowd today. Do you remember, or any of you remember, why Senator Biden was so worried? What was he worried about if Justice Thomas took office and held to this position? Yes,
I think it was that he was concerned that there would be biblical imposition on the law, over the law.
Absolutely. And does anybody remember there was a particular issue that
Abortion. Right.
Yeah, it was about abortion. Yeah. And I think you're right. Feared that, boy, would somebody who holds that view maybe use higher law, the law of nature, to strike down human laws or hold that over the Constitution? But there was a particular worry that it would be applied on the issue of abortion. So that's one story. Here's my second story, and it has to do with actually our students who have a summer abroad program in Strasbourg, France. And a couple of pictures of Strasbourg, gorgeous cathedral, Gothic style, built over 300 years, and pictures of Strasbourg. The reason why we go to Strasbourg is that it's the home of the European Court of Human Rights, probably the most powerful human rights enforcing body in the world. And here's a picture of the European Court of Human Rights, obviously designed with the Gothic architecture of Strasbourg in mind.
Thank you, Matt. Ready to blast off.
Yeah, it's very unusual design, but that's not what I wanted to talk about. What I want to talk about is that every year when we take our students to Strasbourg, we make a visit to the European Court of Human Rights. And we are able to talk with either a judge of the European Court or a lawyer who's a staff lawyer helping judges draft opinions. In this case, we were talking with a staff lawyer and what we annually get is an update on what kind of jurisprudence is taking place at the court. What are the hot issues? What are the important issues? And this year, the court had decided a case dealing with the right to life. There is a fundamental right to life protected in the European Convention on Human Rights. But the issue with regard to the right to life was this. Does the right to life encompass the right to die? So in other words, if I have the right to life, do I also have the right to take my own life or to have physicians assist me in taking my own life? Is that a fundamental human right under the European Convention? And it was very interesting what the lawyer shared with us. She said, and so the court decided that the answer is no. The right to life does not encompass the right to die. And I would have been fine had she ended there. But her next statement was, but that's what the court decided now. 10 years from now, who knows? What an odd statement to add. Because this is a human rights court, right? This is a court that's deciding, as I understand human rights, these are things that are fundamental, basic, core to being human. These are true about human beings no matter what place or time or circumstance. These are core rights. And her statement that, well, 10 years from now, who knows what the rights will be, really caused me pause. And of course, as I've read more from the European Court of Human Rights, I've realized that, wow, the court, although it has had several very strong opinions protecting religious liberty and other rights, also often makes its decisions on the basis of whether there is a consensus in Europe that something ought to be a right. And so, and which of course is problematic. I mean, if we're talking about things that are rights, fundamental, core, basic to being human, how much should that vary over time or place depending on consensus or the views of people within Europe? Now, why did I tell you these two stories to begin class? Here we go. It doesn't feel great to be back in law. But in this presentation, it's because we have shifted. Over time, we have shifted from, I would say, the John Quincy Adams, Clarence Thomas view to the European Court of Human Rights view in many ways as we look at law. Well, in some ways, our session today is not just going to be starting with a couple stories. I hope to tell you one big story, and that's the story of how our thinking about law has changed over the course of, well, 800 or 900 years. How the Thomas view was actually the dominant view. I mean, pretty much anybody who was anybody in legal thinking or a strong legal philosopher believed that Thomas was right. There is some sort of a higher law that is above human law, and that impacts what human law is or ought to be. Now, they call it different things. Some call it the natural law, some the law of nature, the divine law, the law written on our hearts. But whatever they called it, they believed that there was a transcendent standard for law and that it mattered for human law. I think you know that's not the dominant view today. The dominant view is not that there's a transcendent standard that we ought to be looking to, that law is, well, the dominant view is that there is skepticism about whether there is such a standard. And so I want to, I guess, tell that story today over the course of the time that we have together. And how did we come to do that? And then end with, why does this matter to us? Why does this story matter? Now, I realize now that I've told you we're going to cover about 900 years, some of you are looking at your watches thinking, no way. You know, there's no way this can be done, and you may be right. I don't know. But it reminds me that we're going to try to do this, reminds me of an exam that I had in college. I grew up in the Midwest. I grew up in Wisconsin, and I went to the University of Wisconsin at Madison. And through the counsel of a friend who was getting his PhD in Hebrew, I ended up taking Hebrew as my foreign language in college. And I should have known better, I guess I should say. But it was very interesting. And at the end of the first semester, I was ready for my first, I was a freshman in college, my first Hebrew exam. And so I thought, well, I'll probably parse some verbs, or there'll be some vocabulary, maybe I'll do some translation. But instead, I was given a 16-question exam that I still have today. Here's one of the questions. Question 14, philosophy. Sketch the development of human thought. Estimate its significance. Compare with the development of any other kind of thought. Okay. All right, good. Question 2, history. Describe the history of the papacy from its origins to the present day, concentrating especially, but not exclusively, on its social, political, economic, religious, and philosophical impact on Europe, Asia, Africa, and America. Be brief, concise, and specific. And I read that to you because that's what we're going to try to do today. Over 900 years of Western legal history, and as you know, it's going to be a gloss over the top. Normally, the things we're going to talk about, we take 13 weeks at Regent to talk about. We're going to do it in a very short time, and so I'm going to apologize to you in advance. In many ways, this is oversimplifying the story. I believe this story is fundamentally true, but we're going to have to go at a fairly broad level and a simple level.
Jeff, we'll give you 15 extra minutes if you can go into more depth.
Thank you. Thank you very much. I may take you up on that again. By the way, one of my questions, if you didn't see this exam, it was, thankfully they pulled out another exam a little bit later. But question 1 was actually in medicine. You've been provided with a razor blade, a piece of gauze, and a bottle of scotch. Remove your appendix. Do not suture until your work has been inspected. You have 15 minutes. So that was the all right. So let's talk about the idea of, essentially we're going to talk about a shift that has occurred in the way that we think about law. And I think some of you have already turned to the outline. There's an outline, I think, on page 57 of the book that will kind of have the overall outline of what we're going to cover today. But I want to start with what was a dominant view, that there is a transcendent source for law. There's some standard outside of human beings that governs law. And I'm going to argue that that standard, or that belief, that there is such a standard, was the dominant view during the development of the common law, which of course is the dominant form of law in England, comes down to us and still affects us very much today in our legal system. And I'm going to do that, and this is of course very artificial, by just pointing you to, that's a picture of the inside of the European Court. By taking you through just some quotes from some of the main thinkers, some of the foundational people to the development of the common law. The first one we're going to look at is Henry Bracton, who wrote in the 1200s. So Bracton is somebody he was a judge. He was a judge on the King's Bench in England. He was a traveling judge, a judge in air, who went around the country doing justice on behalf of the king. But what he's most known for is a set of books that he wrote, The Laws and Customs of England. And I tried desperately, by the way, to find a good picture or drawing of Bracton. All I could find is this riveting picture of his books. But Bracton is the guy who most people look back on and say, that's the guy who, during the developmental phase of the common law, really helped put it in its shape and form. A lot of the categories that we use, the vocabulary that we use about law, in many ways took shape with Bracton. Okay? And listen to what Bracton had to say about what law is. Now, I'll give you a moment to just read that for a second.